welcome to today's headlines. Justice Nnamdi issue fresh order to IPOB leader Nnamdi Kanu. Justice Nnamdi issue fresh order to IPOB leader Nnamdi Kanu. To my dear listeners, this is today's news. Nnamdi Kanu, the detained leader of the indigenous people of Biafra, has been given permission by the Federal High Court of Abuja to request a mandamus ruling for the Department of State Services to give him unrestricted access to medical care. Kanu said in the lawsuit, which was marked FHC ABJCS 2341-2022 and was viewed by Info Exclusive, that he needed a third-party medical assessment to determine his health status. His legal team was led by Mike Ozekomeleni Fiayi Ejiofor. Justice Nnamdi instructed Kanu's legal team to serve all pertinent documents on the DSS and its Director General, who were listed as the first and second respondents in the case, after hearing an ex parte plea submitted by the IPOB leader. According to the IPOB leader, he would need the DSS to obtain his admission records, medical and clinical notes, nursing notes, observation chart, and documentation during treatment or hospitalization, laboratory test results, pharmaceutical records, radiological scans, images and reports, blood transfusion records, physiotherapy and rehabilitative treatment records, clinical findings, as well as records of diagnosis and prescribed treatment. He emphasized that Justice Ùñçóñdītīønally had mandated on October 21, 2021, that he should have access to 3 people of his choosing, including his doctors. He is specifically asking the court to grant him permission to apply for judicial review in the form of an order of mandamus, compelling the respondent to allow the applicant unhindered access to his medical doctors, to enable them to conduct an independent examination of his present deteriorating health condition. As earlier ordered by the Federal High Court, Abuja, Quorum Honorable Justice B.F.M. Niako, on the 21st day of October 2021, and as required by the express provisions of Section 7 of the Anti-Torture Act 2017. An order of this Honorable Court granting leave to the applicant to apply for judicial review in the form of an order of mandamus, compelling the respondent to avail the applicant with all his medical records from the 29th day of June 2021 to date. Contending that Section 7 of the Anti-Torture Act 2017 provided that a person arrested, detained or undergoing custodial investigation shall have the right to demand a physical and psychological examination by an independent and competent doctor of his own choice after the interrogation, which shall be conducted outside the influence of the police or security forces. The respondent have repeatedly denied the applicant access to medical doctors of his choice to independently examine him, contrary to the order of the court made on the 21st October 2021 and the express provisions of Section 7 of the Anti-Torture Act 2017. Additionally, he said that after his traumatic imprisonment in which he was exposed to torture, cruel treatment, and degradation, his health had gotten worse and that he had experienced a slight cardiac arrest before to being smuggled back into Nigeria. Before his capture, kidnapping and remarkable return to Nigeria, Kanu testified to the court in a verified affidavit that he attended a specialist cardiologist once a week for a physical assessment and medical care. Medical reports containing the medical history of the applicant, as was issued by medical specialists managing the applicant before his abduction in Kenya, an extraordinary rendition to Nigeria are hereby attached and variously marked as Exhibit MNK3, MNK4, and MNK5. That notwithstanding the fact that the applicant has been discharged by the appellate court and his further detention prohibited, the applicant is still being held in solitary confinement in the custody of the respondent, where he is exposed to daily mental and psychological torture and degradation of his human person. The applicant's health condition has continued to take a downward spiral since then. That various medical personnel that attended to the applicant whilst in custody had repeatedly informed him that they could not ascertain the reason for the depletion of potassium in the applicant's blood. That on various occasions, the medical personnel brought by the respondent took the applicant's blood sample and allegedly transported the same to South Africa for screening, and up to the present, there is no end in sight for their trial and error Medicare. Now I've come to the end of our today's news. Please do drop by at the comment section and let's know what your view is all about. Thank you for listening.